Hello students, my name is Liz Attia and today's topic is professional-patient relationships and confidentiality. Professional-patient relationships and confidentiality. So confidentiality comes from the Latin word con, which means completeness, and fidere, which means trust, so complete trust. It means complete trust or to impart knowledge with reliance upon security. So the client or the patient is actually imparting the information on the basis that the information that they're actually telling the health professional will go no further than the health professional, so that their secret will be kept. Ethically and legally, the rule of confidentiality obliges all healthcare workers to not only refrain from disclosing information obtained from patients to others, but also to take every reasonable precaution to ensure that any records of such information remain confidential. And breaching confidence could be deemed professional misconduct. There are 4 philosophical arguments which are used to support confidentiality. The first actually goes to the principle of autonomy, that confidentiality needs to be maintained to ensure that people have control over their lives. It's their information, it's their secret, and they have the right to decide who that secret is shared with. It also goes to the virtue-based argument that there must be trust in the secret, and this trust or this secret keeping is the basis of the relationship between the patient and the health professional. From a communitarian perspective, confidentiality is central to all relationships, especially caring relationships. And from a consequentialist argument, that confidentiality and trust are necessary to ensure an accurate diagnosis and that treatment is appropriate and that you're producing the health outcomes that you want. So patients might in fact lie about their circumstances when they're not assured that their information is going to be kept confidentiality. So there's no transparency in that relationship because the trust is compromised. So in terms, I guess, of the practical implications and what we actually mean then as to how this should actually look in the healthcare environment, healthcare workers should not disclose private information to anyone else and should ensure that records remain private. Patients can give consent for others to access their files, and patients must give consent for one medical practitioner to access medical records from another practitioner. So it must be specific to the individual as to as to how that information might actually be shared. So it can't be assumed within a healthcare setting that information between professionals in that healthcare setting is actually readily available and accessible to one another. There must be consent from the patient or the client for that information sharing. So in terms, I guess, of the legal obligation of where confidentiality comes from, it comes from a number of different sources: in contract, equity, tort, and in fact enacted in statutory legislation. Where it arises in contract is that every relationship either has a verbal or a written contract where there's an understanding of the obligations in that relationship, their rights and obligations. So most contracts between healthcare professionals and patients are informed, and their terms are therefore usually explicitly agreed upon. So in that first initial interview assessment, or in that first engagement with the service, there'll be some communication about what the expectations are of the treating professional in response to the rights of the client. And confidentiality usually features in that discussion, whether it be verbal or in fact in some written form. So courts will generally assume that contracts require the healthcare professional to protect any confidences that may have been divulged by the patient, and any breach of confidence will therefore involve a breach of the contract, and damages can follow if there's some resultant loss. And in fact, just in damage in breach of contract. What do we mean by equity? Well, equity in its broadest sense is fairness. As a legal system, it's a body of law that addresses concerns that fall outside of the jurisdiction of the common law. So in equity, there's an equitable obligation of confidence, and that usually arises where the information has the necessary quality of confidence about it. So it's actually disclosed, and it's quite obvious in terms of the contextual information that it was intended to be a secret. And it must have been imparted in circumstances giving rise to an obligation of confidence. So in sharing that information, it was quite clear that the recipient hearing it knew that the information should not be shared with anybody else. So the breach, where a breach of confidence is anticipated, then an injunction might actually be sought against disclosure of that information. So there might be an application to the court to stop the information from actually being shared. In tort, against the tort of negligence, the standard of care in relation to healthcare professionals and their patients include the protection of confidences, and a healthcare professional who carefully divulges a confidence would be in breach of that standard of care. And if some damage resulted from the breach, an action for negligence would be in fact available. In terms of the statutory provisions, where the enacting of legislation then becomes important in terms of the obligation of confidence, there's three main acts: the Health Administration Act of 1992, the Human Tissue Act of 1993, and the Public Health Act of 1991. So all provide against the disclosure of information and provide a penalty for improper disclosure. So what do the legislations actually say? Well, it's balancing the rights of the individual against also public obligations. And we'll talk about some of the exceptions to confidentiality in just a moment. In terms, I guess, of the legal obligation, or in addition to the legal obligation, there's also in our professional codes of conduct an obligation for confidentiality. It doesn't create any rights for the patient in terms of a code of conduct, but finding a breach might amount to unsatisfactory conduct or professional misconduct on behalf of the professional, and therefore consequences will actually follow as a result of that. So whilst it provides no remedy for the patient, a breach would actually have serious consequences for the professional in terms of misconduct findings. Now, this is what I was talking about in a few moments ago, the exceptions to the obligations for confidentiality. The obligation to maintain client confidence is not absolute, and there are exceptions and defences to the confidentiality obligation. Where there's express or implied consent of the patient to share information, that's an exception. So this only occurs where disclosure of confidential information about a patient may be necessary to advance his or her care. So it's in the interests of producing the health outcomes, and we have the either express or implied consent of the patient. If we have an overriding duty to the public, there's an exception there under the law. So the question here is, are the interests of the public greater than the interests of the individual? And that was specifically looked at in the case of W and Edgell in 1990, which is in the textbook. So remember a few weeks ago, I actually said the healthcare professional has obligations to the public and to the court. Well, in fact, sometimes that's considered an overriding obligation. So where there's some conflict between the obligations to the public and the obligations to the individual in maintaining confidentiality, then the obligation to the public would actually be of paramount significance there, and a breach of duty would be permissible. There are also some exceptions under the legislation itself. So healthcare professionals, as mandatory reporters, have obligations to report, irrespective of confidentiality clauses, information to authorities. So there are some instances where the court allows and in fact requires disclosure of confidential information. The common law requires that communications between healthcare professionals and patients may have to be divulged. There's no doctor-patient privilege in New South Wales, but the courts do have a discretion to prevent disclosure where it's considered necessary, and this is actually covered in the Evidence Act. And I'll ask you to consider what those mandatory disclosure requirements are. So when there's actually risk to the health of, so mandatory reporting where there's a risk of the risk of harm to person or property, that's one of the exceptions under our mandatory disclosure rules. You'd be aware that in terms of child protection, we also have mandatory reporting requirements. So where there's risk to child of imminent harm or danger, under the Mental Health Act, there are also exceptions. So where the person's at risk to harm themselves, we actually have disclosure requirements. Where there's the likelihood of criminal action, we have mandatory reporting requirements. So the law there seeks to actually balance, as I said, the rights and the interests of the individual against the public duties that a health professional actually has. And the public duty would be considered to be of paramount importance. Also under public health law, there would be exceptions there. So under the Public Health Act, if there's risk of infectious diseases, the New South Wales Department of Health, and under our public health responsibilities, we have requirements to disclose information under the Public Health Act to the New South Wales Department of Health for infectious and communicable diseases reporting. We go through this in a few lectures. We go through that in a little bit more detail, but that brings our lecture for today to a close, and thank you very much.